Picture this. It's 2 a.m. and you're sitting with your jurisprudence textbook and you just read this sentence. Shh. What the hell does that even mean? Here's a crazy thought. Imagine tomorrow the government passes a law saying every Indian must touch their parents' feet before leaving the house or pay 500 rupees fine. Now think about it. Would you follow it? Is it a law? Your grandmother would say, finally, a good law. But your friend might say, this is ridiculous. Here's where it gets interesting. Different jurisprudence thinkers would give you completely different answers. For instance, one would say, it respects Indian culture, so it's valid law. Another might say, Parliament passed it, so it's definitely a law. It doesn't matter if it's good or bad. The third would say, it's only a law if police actually catches the persons and fines them. So, same situation, three completely different answers. And that, my friends, is why jurisprudence drives everyone crazy. But here's a secret. Once you crack the code, you'll realize these complicated sounding theories are just different ways of answering simple questions we debate every day. I am Santosh, and today I'm going to break down jurisprudence like your best friend would. No fancy words, no confusion. So, grab some chai and let's decode this. So, what exactly is jurisprudence? Think of this way. You know how to drive a car, right? You know the rules. Stopping at the red light, don't speed, wearing a seatbelt, etc. But have you ever wondered why we have these rules? Who decided them? What makes them valid? That's exactly what jurisprudence does with law. Unlike regular law subjects like PNS, murder is a punishable offense. But jurisprudence asks bigger questions like what makes killing wrong? Who decides what's a crime and what is not? Why should we follow all these laws? So basically, it is the philosophy behind the law. Philosophy means what is good and what is bad. And just like your friend who always asks, but why, about everything, that's jurisprudence. Usually, jurisprudence goes beyond the rules. Like, why these rules have came? Who brought these rules? Who made it enforceable? Etc. It is something like thinking like a philosopher. And now, why does everyone think jurisprudence is hard? There are few reasons why everybody thinks jurisprudence is hard. There are first thing is the language. This language is very complicated. Instead of saying rules, they say normative legal frameworks. Instead of ideas, they say jurisprudential paradigms. And coming to the second reason, there are too many people saying different things. For example, Austin says one thing, Hart says something else, and Dworkin disagrees with the both. It's like having 10 friends giving you 10 different directions to the same place. However, it doesn't mean that law is always same. It also keeps changing. It evolves according to the society. For example, if you take preamble, initially it was said it is a part of the constitution and then it is not. Again it is a part. Again it is not. But at any given point of time, it is either part of the constitution or not. There is one clear answer at any given time. But it is not like with the jurisprudence because jurisprudence says everything is right. There is nothing called this is wrong. Everything becomes right in jurisprudence. And law students are not expected to know everything about the jurisprudence because it is not law but philosophy of the law. And coming to the third issue, there are no clear right or wrong answers. For example, in criminal law, murder is wrong. But in jurisprudence, well, it depends on your philosophical perspective. Hmm. And coming to the fourth problem, it feels abstract. Regular law subjects deals with concrete things like contracts, crimes, property, but jurisprudence deals with concepts like what is justice, why do these laws exist, what is good, what is bad, like that. There are no clear concepts. But here's the secret. Once you understand the basic pattern, everything becomes easy. If you look into the pattern, every single thinker in jurisprudence is trying to answer just three questions. The what is law means the definition of it, and what should law be, the ideal version, and how does law actually work in reality. That's it. Every school, every thinker, and every theory, they all just giving different answers to these same questions. For example, take natural law school. It says Law comes from the God or nature, and law should be moral, and law works when it's just. If you take positivist law school, law is what government says. Law should be clear and certain, and law works through force. Coming to the realist school, law is what judges actually do, and law should be practical. Law works differently in practice than on paper. If you see the pattern like what, should, and the ideal thing, you get the pattern. Same three questions, different answers. Now, let's look into the meaning of the law, and there are different ways to understand it. Before we get into the examples, let's understand what law actually means, because here's the confusing part. Law means different things in different contexts. If you look law in the general sense, law is a body of rules which governs individuals. Means it governs the behavior of individuals. For instance, if you take IPC, it has some type of acts which are prohibited by the law. If any person commits that act, then he will be liable under IPC and he will be punished. Same like Indian Contract Act. It contains the requirements to be followed by the parties to enter into a contract. If the parties doesn't follow the requirements given in Indian Contract Act, then the contract becomes void. Next, law is a set of rules that resolve conflicts. If any person trespasses into your property, then you approach a court to resolve your conflict. And that is the law. Comes to the third thing, law is means to achieve justice. Considering the previous example of trespass, you approach a court for a compensation and get justice. And the last one is law is an instrument of social change. If we take child marriages, it become illegal after passing the Child Marriage Prohibition Act. Until then, it is not. After it was prohibited by law, then it leads to the constant social change. And coming to the law through statutes. If you look into the statutes like Indian Contract Act, Constitution, Factories Act, or any act, it also defines law. For example, if you take Indian Contract Act, it deals with the laws relating to the contracts in India, which means it determines the circumstances in which promises made by the parties to a contract shall be legally binding and enforcement of the rights. Simply, it says the rules and regulations that should be followed while entering into a contract. And whereas the constitution says about the fundamental law of the land, it gives power to the all the organs of the government. All acts other than the constitution derives its power from the constitution itself. Similarly, the Factories Act. It deals with the various problems concerning the safety, health, and efficiency, and also the well being of the persons at different workplaces. And finally, if you look into the Air Act, it is brought to control and prevent air pollution in India. Now, coming to the real examples that make sense, let me give you examples that actually make sense. For example, child marriages. Natural law thinker says child marriage is wrong because it violates the natural human dignity. Whereas the positivist school says child marriage is illegal because the Prohibition of Child Marriage Act says so. And realist school says child marriage still happens despite laws because enforcement is weak. Same issue, three different approaches, and that is called jurisprudence. Coming to the second example, we let us consider unjust laws. If a government passes a law saying no one can wear blue shirts, it is unjust, right? For that, the natural law says this law is invalid because it's unreasonable. According to positivist, the law is valid because proper authority has made it. But according to the realist, the law's validity depends on whether people actually follows it or not. Starting makes sense, right? Okay. Now look, jurisprudence seems scary because it's taught in a scary way, but at its heart, it's just different ways of thinking about something you encounter every day, like rules, laws, regulations, etc. Think of this way, you and your friends might have different opinions about the best cricket player. Some focus on the statistics, some on the techniques, and some on impact. But you're all talking about the cricket, just from different angles. And that's jurisprudence, means different angles of law. The key is simple. It is stop trying to memorize everything and start recognizing the patterns. Every thinker is just answering three basic questions differently. Jurisprudence is approachable, means you can understand jurisprudence by simplifying and logically approaching it. It also contains different perspective of different thinkers. These are the key takeaways. There are three question framework. Remember the three fundamental questions that forms the basics of jurisprudence. Those are: what is law, what should law be, and how does law actually work? The definition, the ideal one, and in reality. The second thing, recognize the pattern and not memorization. Focus on understanding the patterns than memorization. And coming to the third takeaway, if you observe this, it has same questions but different answers. There are n number of answers for the same question, that is law. Law has so many definitions in jurisprudence. Everything is considered as law, and try to understand the philosophy behind the law. And most importantly, stop thinking it's impossible. These concepts are actually logical once you see the pattern. You got this. If this helped you understand jurisprudence better, hit that like and subscribe button. I will make more videos breaking down each school in detail. Remember, you're smarter than you think.